Attention, attention. Are you tired of expensive, low-quality web service providers? And are you looking for stunning, amazing, high-quality websites and want your website rank on first page of Google? तो आपकी तलाश खत्म होती है यहाँ. Please contact People Inc. on 510-449-9049, 510-449-9049, or visit them at www.beerbulls.com. Beerbulls Inc. offers award-winning custom-built websites, web and mobile application development, and internet marketing services. So contact कीजिए Beerbull Inc. को 510-449-9049. आपको satisfy करना और hard work करना, यही Beerbull Inc. का मकसद है.
Is your credit card debt driving you insane? Don't panic and claim bankruptcy. Don't consolidate and end up worse off than before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success.
The Shah Peerally Law Group is now opening its second office in San Francisco. After years of popular demand, the law group has finally decided to make the big jump and has its presence in San Francisco. For more than 10 years, the law group founded by the prominent attorney Shah Peerally has been dedicated to the immigrant community. The law group's new office is opening on February 20th, 2015, at the corner of 21st and Mission Street in the great city of San Francisco. For more information, call 415-643-4342 or 510-742-5887 or email sf@peerallylaw.com. Choose excellence. Choose the Shah Peerally Law Group. No attorney-client relationship is created by this ad.
The new Attorney On Air app is now available to download on your iPhone or Android. Get access to the latest information and interact on the immigration and debt settlement blogs. That's not all. The app has plenty of entertainment as well. Listen live to the Shah Peerally Law radio shows. Go to www.attorneyonair.com to download it for free. Yes, that's right, for free at www.attorneyonair.com.
If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, Attorney Shah Peerally can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shah Peerally is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shah Peerally, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello, everybody. Assalamu alaikum, Sastikal, Namaskar to all the listeners. This is Attorney Shah Peerally for the Shah Peerally Law Show, and we're going to talk about immigration and debt settlement. And today I have on the board with me German, and thank you very much, German, for helping me. And anything I'm going to tell you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office, 510-742-5887. 5887. We speak several languages, including Hindi, Punjabi, Urdu, Telugu, and French, and Creole, and our San Francisco office speaks Spanish, Italian. So we have a great team to help you. If you have any questions, of course, call our office, 510-742-5887. And today on the studio line, I have with me German, like I said, and the number to the studio is 408-912-5565, 408-912-5565. And before I start taking the calls, of course, I will make few announcements. First of all, the H4 EAD rule is coming soon. Hopefully, there will be no glitch on this. As you know, there are some glitches always, but at this point, the only thing that we have not seen is a revised I-765 form, which is supposed to be issued in order for people to get their EAD. We have published a draft instructions on the website h42ead.com, h42ead, but we don't have the actual revised form. So for those who are trying to apply on their own, if you apply with that form that they have right now, it will be rejected. So make sure that you're hiring someone or you're doing a proper job, because you don't want this to be delayed. This is new. Even lawyers who have been practicing for a long time might have issues on it. The only reason we know a little bit about H4 EAD more than most out there, because we have worked on it for years for that law to pass. So we are proud now that it's hopefully coming in the next 1 week or so. But until we start seeing approvals, we cannot really tell on how it's going to work. Plus, we don't have the revised form yet. The form that applies for that EAD, the I-765 form revised, is not yet out. I repeat that. So, but still, we are starting to take cases, gathering documents for clients, and we will be ready, hopefully, to apply as soon as they give us the revised form. And May 26th is there too. And of course, if you have any questions now on immigration, whether it's H4, H1B, EAD, PERM, labor certification, please call us. The studio number is 408-912-5565, 408-912-5565. And Javan will let me know if anybody's calling. So this is Shah Peerally. You're live on air. Hello? Okay, I think I'm still having some issues on that. So the number, we are having some calls dropping, unfortunately. But hey, these are technical issues. So feel free to call again. This is Shah Peerally. You're live on air.
Hi, Shah Peerally. This is Neeraj. Good morning.
Hi, Neeraj. Good morning, sir.
I have a quick question. Like, I have a EAD and I do have a H1B valid. I'm traveling to India next month and will be coming back in July. So what should I use to come back? Like, I should use my H1B to come back, or I should use my EAD to come back?
Well, the entire question is kind of a big question, because all depends what you want. If you come back under the AP, the advanced parole, which is what you're calling the EAD, then you won't be using the H1. And if you're not using the H1, if anybody is depending on you on H4, they will not have H4. So if both you and your spouse and even your children are also on pending adjustment of status, that means you get the EAD and the advanced parole, then you can use that. Otherwise, there's no real reason to stay on H1B once you get your EAD and AP. But sometimes in certain situations when you need to be kind of maintaining an H4 and things like that, then you do that. But it's your choice. I prefer, once I know people are pretty much secure, I-140 has been approved, 180 days has passed, I recommend them to use their AP, their EAD instead of the H1, because it gives you a lot more flexibility. So it's your choice, really, but my preference is always to use EAD if you don't have anything attached to the H1 that you need to maintain. But it's your call, really, if you want to maintain your H1. Sometimes people do that because they're worried that their EAD, their green card will be denied or something, their adjustment, then they want to use the H1 if they can continue. So this is the only reason people maintain the H1, okay?
Okay, but there is no reason I can use either of them, right? Like, so I have valid visas for all of us.
But if you come on H1, you will have to basically maintain the H1. But if you come on the EAD, then you're pretty much free as long as you meet all the requirements. Yes.
Okay, great.
Okay.
Thank you, sir.
Okay.
Thank
Good luck to you. Let me take another caller. This is Shah Peerally. You're live on air.
Hey, Shah. This is Malik from San Jose. First of all, I want to thank you for the wonderful service which you have been doing for all of us.
Oh, thank you so much, Malik, for your kind words. It's important to hear that.
Yes. So I have a quick question. I have an approved I-140 from my current employer, and after that I got promoted and changed into a new role. So does that mean that my I-140 gets out of date and it needs to be redone?
Yes and no. This is the problem. It's a very, very tricky question. The way it works, if you're moving to a same or similar position, they just added some kind of additional responsibility, and you're still within that realm, you might be able to get away with not filing a new one. But if they change you completely and they are not planning to send you back to the position when you get the green card, then yes, you might have to redo the perm. Sometimes people, because if you want to do the I-140, you will have to start from scratch again. So it's a little bit tricky, but you don't have to, but the rule works this way. If you want to get the green card, you'll have to go back to that job before the green card itself, probably a few months before. You have to go back to that job where the I-140 was approved because it's for future employment. So the answer is yes and no, depending on how much change you are doing in your job, okay?
Okay, and does it also impact the H4 EAD if I have to apply for that? Or
No. Your I-140 is there. It's alive. You can use that. Because filing a new perm and a new I-140 will not affect your current I-140. No. Okay?
Okay. Yeah. Thanks, Shah.
Okay, then. Good luck to you. You can use that same I-140 for your H4. Let me take another caller. This is Shah Peerally. You are live on air.
Hi, my name is Sanket, and I have a question. One of my friends, she has applied for business visa B1 as she wanted to attend one physiotherapy workshop here, and she got B1 B2 visa, and somehow she couldn't able to make it to the workshop. So now, if she wants, since she received a B1 B2 visa, can she be visit here as a visitor?
Yeah, because that's why it's called a B1, B2. The B2 is for what we call a visit in terms of tourism. But the question is, at the airport, they have a right to ask her the question, did you originally file this just to get the visa, use that conference? They might ask her that, but it depends on the officer at the airport. But technically, to answer your question, yes, she can use it for visiting and tourism, but they might ask the question. They might or they might not ask. It all depends on the officer at the airport, okay?
So, but do they have, can they see that she has applied for just B1 and now she is coming as a visitor? Can they see that in the system, or the officer can just ask?
Yeah, they see that in the system because now everything is under the I think it's ESTA. They have all those records. Before, back in the days before computer, and they didn't keep it under the record. But now, no, they put notes in there what was the original application. And actually, once they pull the name, the original application will appear in front of them. But that doesn't mean anything. If it was a genuine application, for example, let's say I apply for a conference from India. I want to come here, but then for whatever reason, I have a good reason, I couldn't attend because I was sick, or later on I realized that the conference doesn't want me or it's not worth it for me. As long as she can give a good reason, they should not make any problem. But the problem is that at the airport is discretionary if they allow you in or not. So an officer who's overzealous, who wants to really give a hard time, they can. But most of the time they don't. But it's all a case-by-case basis and your luck. Okay?
Okay. Because her sister is also here, so maybe they can raise a point that your intention is like this or something like that.
Yeah, they can raise a lot of intention. The problem is they go what we call circumstantial evidence. Circumstantial evidence is they look at the totality of circumstances, everything surrounding the case, and see, but they can make a lot of permutation. The problem is at the airport they have this thing called discretionary power. Discretionary power means they can decide on their own if they feel that person has to be let in. But 90% of times they let people in if they are in doubt. But if they think that they have a strong situation, they can always refuse you. And that's very hard to tell, and nobody can really assess that. Because genuinely, if she applied and she has not cheated and she just couldn't come to the conference, she didn't do any kind of fraud or anything. But the problem is just at the airport, how do they see it? That's very hard because that's kind of going in the head of the officer. But at this point, yeah, the B1, B2 allows you for both, coming for business, for seeking business, not to do business, but looking for business, but also allows you to come to as a tourist. Okay?
I see. Okay, thanks. Thank you very much.
Okay, good luck to you. Let me take another caller. This is Shah Peerally. You're live in here.
Good morning, Mr. Shah. My name is Desh. Thanks for taking my call. I was wondering if you could quickly reflect on. I believe I had heard that there was some relief announced for these backlogged 140 cases as a part of the executive action. So I was wondering if you'd reflect on that.
No, there's none. This is just a rumor that has been running around. There's nothing else they give to I-140. They give only to the H4. Yeah. What I've been saying that a little bit. Unfortunately, let me tell you how it happened. When we started fighting for the H4 EAD, it was down around 2010. There was a proposition by USCIS that was sitting in their box to give EAD to the people, all right? And then what we did, a bunch of people, a group of people on H4, they started petitioning the government, and myself petitioned the government to revive this proposition. And they have been going back and forth. And then just around 2011, 2012, other people tried to push more stuff into it. And President Obama, when he made his announcement on the White House, he kind of put everything in one basket. But then when they released it, they released the original thing that they themselves proposed that we have pushed. They have not released anything on the I-140. I was hoping myself, maybe we'll get the whole thing. But the truth is that nothing. They have not given anything to I-140 people. And unfortunately, that's sad, but that's what they have been kind of political promise. Even the H4, it has been a big struggle. But there's nothing on the I-140 so far I've seen. I know there's some stuff that has been proposed through Congress, but lately, if you just read the news, nothing is coming out of Congress which is a favor of immigration. The only thing that I've been hearing from Congress is how to enforce the law more strictly rather than give anything. So at this point, until it comes from the White House and it is clear on the Federal Register and it becomes law, you cannot really count on those because those are propositions and we get them every day, but nothing is clear. And unfortunately, some other people took it and made a big noise about it, and for whatever reason, but I don't see anything so far. So I wish it was there, but I hope they will pass it. But what they really need to pass is to reduce the waiting time for people on EB2 and EB3. That's something that will be more concrete, save everybody. Okay?
Okay, great. Thank you.
Okay, good luck to you. I know a lot of people are calling about this issue, but it's very important that we made clear. There was... unfortunately, the way the newspaper has picked up the story, they don't know really the technicalities. So I see a lot of newspapers kind of confusing the issue of I-140, H4, non-immigrant status. They all mixed it in one. This is like we call in our country making a masala of everything. But it's not. It's not the real thing. The real thing was just H4, and that's what we got. But we hope other things will come down the road. But at this point in time, nothing has come up. It's all propositions, it's all fight, it's all activism, but nothing has come. It's unfortunate, but we have to tell the truth. So, ladies and gentlemen, we will be still taking calls. Your number to the studio, 408-912-5565. And if you have any questions, of course, you want a private consultation, the number to our office, 510-742-5887, 510-742-5887. We're going to take a quick break, and we will be back after those messages. So keep listening. This is Attorney Shah Peerally, and anything I told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to call, 510-742-5887. And German will be back in a few minutes. So let us take a quick break and we'll be back.
Is your credit card debt driving you insane? Don't panic and claim bankruptcy. Don't consolidate and end up worse off than before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success.
The Shah Peerally Law Group is now opening its second office in San Francisco. After years of popular demand, the law group has finally decided to make the big jump and has its presence in San Francisco. For more than 10 years, the law group founded by the prominent attorney Shah Peerally has been dedicated to the immigrant community. The law group's new office is opening on February 20th, 2015, at the corner of 21st and Mission Street in the great city of San Francisco. For more information, call 415-643-4342 or 510-742-5887 or email sf@peerallylaw.com. Choose excellence. Choose the Shah Peerally Law Group. No attorney-client relationship is created by this ad.
The new Attorney On Air app is now available to download on your iPhone or Android. Get access to the latest information and interact on the immigration and debt settlement blogs. That's not all. The app has plenty of entertainment as well. Listen live to the Shah Peerally Law radio shows. Go to www.attorneyonair.com to download it for free. Yes, that's right, for free at www.attorneyonair.com.
Ladies and gentlemen, this is Shah Peerally. We're back on air right now. I don't know if you have more callers, but you can call 408-912-5565. So, yes, German is telling me, yes, we have some more callers. This is Shah Peerally. You're live on air.
Hey, Shah, this is Reddy speaking. I have a quick question regarding H1.
Yes, sir, I'm listening.
Yeah, the question here is I got my I-140 approved and 3 years extension is completed. So I'm on 3 years extension of I-140. And I got offer from company B with H1 transfer for 1 year. So will it still be reasonable or is it risk for me to move to company B?
Well, that's an excellent question because you have to understand the law to know exactly what is happening. For one, usually when you have an I-140 approved, you do a transfer and extension, you get 3 years. But when you transfer to another company, they still rely on that I-140. Once you pass 6 years, they rely on that. So at this point, the problem that you face is, right now, let's say you move. You have 1 year in your hand from company A to company B, and let's say the company A, they revoke your I-140. You'll be stuck because you won't be able to do another extension or even to move, okay? Then this is a risk that you take if you move for 1 year, because in 1 year it's very hard to get another labor approved and an I-140. So it is risky to do that. But having said that, if you are with a company that you know full well they won't revoke your I-140 from company A, then you're fine. You can use that same I-140 to do more extension or even transfer. The whole question will be that your lifeline is other than that I-140. As long as this is alive, you're okay.
Okay, so if company A withdraws their I-140 and if I'm not able to get I-140 approved with company B, then I'm in risk.
You're in big risk because you're in risk in twofold. Also, people get confused because some people think because you already got 3 years extension, when they do the transfer, they get the same 3 years. No, it's not transferable. That every time you do a transfer and an extension, the I-140 is independently reviewed. Not the I-140, but the H-1B is independently reviewed based on that I-140. That means you will get it according to the I-140, not what you already have. So in your case right now, you can give me a call. I can assess it in more detail at the office. But at this point, it is risky. Okay?
Thank you,
It
sir.
is risky. I will not move until I make sure that I-140 will still be alive when I move. Okay? All right?
Thank you.
Okay, give me a call if you want me to kind of go into details. 510-742-5887. Let me take another caller. This is Shah Peerally. You're live on air.
Hello.
Hello, hi.
Hi. Can I speak to Mr. Shah Peerally?
Yes, you're live on air. This is Shah.
Hi. I have a question regarding green card processing. So we have applied for green card processing for our in-laws, and they would be they are still in the process of getting the card. So they have been waived from the interview. So we got the letter for that. But they would like to travel to India in the next month. And we haven't been able to apply for the advance parole since it takes about 3 months in processing. So I was just wondering, what are the consequences if they do travel before getting the card in hand? So if they come back later on when the green card is already, they have it in hand while coming back, but then they had to depart from U.S. before the actual processing was through.
This is another excellent question because it goes to the concept of adjustment of status. If you don't have an AP approved, an advance parole, as soon as they leave, the green card gets canceled.
Oh. Okay.
So you don't get it. Automatic. It's an automatic process. And even if they give it to you by mistake, they can take it later from you. So that's why we tell people if they want to travel in the middle of the process, always make sure you have an approved advance parole. The advance parole basically says, continue processing my adjustment of status and give me a parole to leave the country. Otherwise, the other option now, you can cancel the adjustment of status, let them travel, but then you will have to do what we call consular processing. Because as soon as you file also for the adjustment of status, technically, their visitor visa also has been canceled. So now it's very risky. They cannot travel because you did an adjustment of status. The second thing, getting the letter that they say they waived the interview, that's not really true all the time, okay? Just because sometimes they generate that letter automatically doesn't mean they will waive your interview. Because at a later stage, they reserve the right to call you for an interview. So the safe side right now is to postpone the travel. Hopefully within a couple of months they get their green card, then they can go. Otherwise, if they go, you'll have to start over with the National Visa Center processing, which is a long process. Plus, their visitor visa will be canceled. They won't be able to come back. So good you call, because if they had traveled, they would have lost it. Okay?
Oh, my God. Thank you so much. Thank you for the information.
You're welcome. You're welcome. And if you need help on that, give me a call, 510-742-5887. Let me take another caller. This is Shah Peerally. You're live on air.
Hi, good morning, Shah Peerally. This is Sri Lakshmi. I have three questions regarding my situation. My husband is on L1A and I'm on L2. I got a EAD and I have been working for the past 3 years. And this year my H1 got selected in lottery. And I have three questions in this regard because if my EAD, L2 visa and I-94 expires by end of November this year. So do I have to go back to India and get the H1 stamping before I start working over here? Or can I go ahead and stay and work over here with the new petition even after my I-94 expires?
No, because your I-94 is expiring in November. And if your lawyer did your H1B and it was done to a change of status, that means on October 1st, automatically you're moving on H1. Even you want to keep the L2, it's gone. So you don't have to leave the country. So that's to answer your first question. But also you have to, as long as it merges or it is after the H1, the I-94, automatically you change status to H1B. You're telling me November your L2 is expiring, but and you just got into the lottery of the H1B. Is it approved already? No.
Not yet. We are waiting for the result.
Okay, check with your lawyer if they did a change of status. That means automatically you will move to H1. If they didn't do a change of status, then yes, you will have to leave the country or do an amendment on the H1 to just do a change of status, okay?
Okay. And the second question I had is, these 3 years that I worked on LA L2 EAD, would it count for this H1 6 years?
No. L2 and H4 don't count, okay?
Okay, and the third question that I have is, my husband is his visa also expires on L1A, and he is kind of like, he completes 7 years of his work or stay in US. Can he move to H4 and stay here?
Yes. H4 doesn't count. So what you need to do as soon as possible, get yourself an I-140, and then as soon as you get that, you will be able to get him an EAD. So give me a call at the office. I'll guide you what needs to be done at this point, but right now you're safe, okay?
Okay, sure. Thank you.
The number to my office, you're welcome, 510-742-5887. German is telling me the lines are full, so I'll take some more callers. This is Shah Peerally, you're live on air.
Hi, Shah. Good morning. And I have a general question. Hey, guys, I'll take the answer offline. So my question is, so you said the green card is basically for the future employment, right? So say, for example, if a person files for a green card, so his position might be like X position, say for like an example, like a staff engineer. But nowadays, because the GC is going like a years together, so he might have internally promoted to be like a manager or something like that, right? So does it have to make any difference if he is in the same company? Does he have to do any I-1?
No, it doesn't make any difference if they send him back to the position. But the problem is most companies doesn't like it, because if they promoted you to another position, by the time you get your green card, then that position is no longer available or something. So that's where many companies will tell their candidates, no, we have to file a new labor now because we changed your position. But that's up to the company, how they assess it and how, if the job is still available. Because I remember we have cases where there are specific needs that are required under the perm, and then by the time the green card is coming, this stuff, nobody uses them anymore. So this is a problem we are having, because the law is not matching with technology and positions. But the truth is that when the green card is coming, they have to send you to that position where the green card was obtained. If it is a lower position, that's a lower position. But this is just the requirement. But of course, many companies don't want to take chances. So they ask you to refile a new case and borrow the priority date. Okay?
Yeah, but because nowadays it goes like a 6 years, 8 years. So the person who filed like a very like a basic phase. So now after like 6, 8 years, of course he would have got promotions, right? So
I agree with you.
There is a lot of confusion. I don't know how those things work, because most
it doesn't
of the
work well. It doesn't
go
make sense. It doesn't make sense, but that's how the... Yeah, I agree with you. The problem is just the law has not catch up with technology or the modern world. And still we are like 10 years behind on the law when it comes to technology. And this is what's causing many problems out there. But luckily some people are able to get their things done, but other people are suffering because of that. So you're right, but it's all the companies' call, how they will place you, okay? All right?
Okay, yeah, thanks.
Okay, good luck to you. Let me take another caller. This is Shah Peerally. You're live in air.
Hi, Dr. Shah. So this is Ramesh from Sunnyvale. I have a question.
Hi, Ramesh. Yes.
So actually, I work for a company here, and I have my I-140 approved.
Yeah.
So what I was have question is, so now for my wife, if I apply for EAD and at that time if I transfer from one company to another, so what is the situation that I'll be in?
Well, we can only guess, because from what we understand, if at the time, the same rule as while you do a transfer, if at the time of the transfer your EAD is good, you are good. I mean, at the time of the transfer your I-140 is good, you are good. And if you get the EAD for maybe 1 year or so, it will still be okay. But the problem will be, let us see if they ask to transfer the H4 and then at that time they ask for the I-140. The rule is simple. As long as the I-140 is alive, she should be fine. But if the I-140 dies, then there's a question mark here. We are waiting to get an answer from them. But because when you move, if you don't have an I-140, not only you cannot do an H-1B transfer, you cannot do an extension. And I assume also the H-4 will have the same problem. But at this point, they have not yet come up with an exact rule. But as long as your I-140 is good, she should be good.
Okay, thank you.
You're welcome. So just to let Ramesh know that the question is a little bit tricky for those who don't understand, I wanted to clarify this. The I-140 that they're looking for doesn't have to come from the same company where you're working right now, okay? As long as the company, the I-140 is good, it's the same rule that applies for extension or transfer. As long as the I-140 is good, it will be good to keep working on it. So the same rule should apply. So let us see how they are going to really work on this H4, because this is a new concept. They would probably come with some question and answers soon, but they have not come up with anything. Let me take another caller. This is Shah Peerally. You're live on air. Hello?
Good morning, Ali. This is Satish calling.
Hi, Satish.
Yeah, hi. I just wanted your help on this particular question. This is regarding my green card processing. Since my birth was not registered within 1 year of birth, so they asked for some affidavits. Okay, so affidavits, they are done in India, and after creating those affidavits, I got I got passport for my parents. Now, their name in my passport and in their passport, it is slightly different, because since Telugu is a phonetic language, the spelling was not exactly matching. So, does that create any problem?
Not really, if you explain clearly what has happened. As long as they don't start thinking that you are not matching, it won't create problems. What you need to do, put a lot of secondary evidence. What has happened in your case, it's a very good question you asked, because it's happening recently a lot. India now has this new system where people are going to look for non-availability certificate, and they're giving them what we call the late birth certificate. What the USCIS have said on their RFEs and their requests is whenever you're getting a late birth certificate, it's still considered as not a primary evidence. So you still have to put more secondary evidence to back it. So what you will need to prove, for example, medical records. For example, you put school records, ration cards, and then all this should match. And if you have any discrepancy on your parents' passport, then they don't require your parents' passport, by the way. So you might not use that. There's no purpose. But you have to look at every evidence that you provide. There's no inconsistency. If there's any inconsistency and you need to provide those evidence, you need to give an explanation. So when it reaches this point, it's always good to have someone look at it before you send. But otherwise, just make sure it's more logical than law at this point. You need to be looking for inconsistencies. So if, let's say, for example, you have to provide a certain paper and there's an inconsistency which is very innocent, you need to explain it. Otherwise, don't provide that evidence, because it will create more needs to explain. Because you're not lying. It's just a mistake that happens a lot in India and countries from South Asia. So look at it carefully, and if a lawyer is working on that, make sure that they check it. Because oftentimes they will just put everything that you give them, and they don't check it, they don't explain it. So make sure that you're checking it, or have the lawyer check it, or give me a call at the office. I'll check all your paper before you submit them, okay?
Sure. Just extension of this question. I got these affidavits done in the last November, and I'm going to apply it now. So do they have any shelf life affidavits? Like, they should be done within 6 months before.
No. There's no expiry date. An affidavit is an affidavit. An affidavit can stand even when someone dies. That's why people make affidavits. So an affidavit is basically a written testimony. That's the definition of it. So it's just like you're going to court testifying, but you cannot come to court, so you put it on paper. So no, an affidavit is good. It has value as long as it's done properly. That's fine.
Okay. So affidavit is an affidavit whether it is done in India or US, and they carry same value, right?
Yeah. No. Well, in India they do it different way. It has to be a valid affidavit under the law of the country which it is made. Correct. So, for example, India has those papers which has you have the stamp on the top and things like that. In America, it's not the same. It's just regular paper, and it is notarized by a notary republic, which is who is not a lawyer, by the way. So a lawyer cannot certify an affidavit. It has to be a notary public. So it's different rules, different countries, but an affidavit is good as long as it's recognized in the country where it's coming from. Okay?
Oh, okay. Thank you.
Okay. Good luck to you. Let me take another caller. This is Shah Peerally. You're live on air. Okay, I think we don't have any callers right now. So, ladies and gentlemen, thank you very much for calling. We have another, I think, 10 minutes or so left. So you can still call. We will be taking the call. The number is 408-912-5565. And ladies and gentlemen, everything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. As you know, there are many things happening on immigration. Unfortunately, there's such an influx of information that even for lawyers, even me who follows pretty much everything, there is a situation where sometimes you get confused because there are bills that are proposed by senators, bills proposed by congresspeople, bills that are refused by this and that. A law works this way. It is proposed by the Senate or by the House of Representatives. It goes into a vote system, so it has to get a certain majority, and it has to get a bigger majority sometimes in Senate. Then it goes on the desk of President Obama, who has a right to either sign it or veto it. And the bills that we have seen on immigration, for example, the H-4 EAD or the other bills that you've seen in immigration, has not come from the Congress. It has come from an executive power of the President Obama, and directly from the White House, sometimes to public comments, a bit like the H-4, and then it has signed directly. It has not gone to Congress. And this is why you see a lot of fight going on. But at the same time, the argument of President Obama is if Congress is not doing anything, what is he supposed to do? He cannot kind of have his hands tied. On the other hand, Congress is arguing that the law is not made by the branch, executive branch. It's made by Congress, and we are supposed to have a say on it. So this is what the tug of war you're seeing here, and that's what's creating so many confusions. Let me take another caller. This is Shah Peerally. You're live on air.
Hi, Shah Peerally. Good morning.
Good morning, sir. How are you?
Yeah, I'm doing good. Yeah, I have a question regarding H1 to H4.
Yes, sir.
Yeah, so currently my wife is on H1, okay? And she's not on the project, or she's not getting paid since 2 months, okay? And so what are the implications if she wants to come back to the H4? My first question is there an automatic conversion of H1 to H4, or do we need to file explicitly?
She has to change status, but she has a problem. If she was an H1, she has not been working. Depending on the time, she might be out of status according to USCIS on their books to change status. So you have to be very careful, and this is something I'm going to tell to everybody. Whenever you are on H1, you don't have projects, and you're passing 30 days, you better move to another status or find a project and get moving to another company, because unless the company is paying you for the idle time, you will have problems when you do change of status, either even transferring. That's why they ask for latest check stub. So, yeah, give me a call at the office. I'll look at it and tell you what is the best course. Worst case scenario, if 180 days has not passed since she was out of work, you can always just leave the country and come back on H4 and then do your EAD if you need to. But right now, the important part is if she's not working and she's not getting paid and she's on H1, there's a big problem. It can come and harm you down the road. Okay?
Okay.
Okay. Good luck to you. Give me a call, 510-742-5887. Let me take another caller. This is Shah Peerally. You're live there.
Hi, sir. This is Surendra from Santa Clara. So
yes,
I have a question.
Yes, sir.
So this I-140 EAD is no news on that. So what do you think, like, as per your experience? Because there are people since many years on that status. So it is very, very difficult to continue on. It is a
Yeah. Well, the thing that I am proposing, this is I have not really fought for the I-140 EAD because I think it will be very difficult to attach something to something very non-permanent. But what I propose is that we go directly to the Obama administration, like we did on the H-4, and ask them to reduce the waiting time on the green card. If the waiting time on EB2 is 1 year, and EB2 maybe 2 years for India, people are still okay because 1 year is not a big gap. And they can do that because the reason they can do that, many of those visas have not been used. What they have done, they have just dumped the visas that have not been used and they keep borrowing from the next year. But if they recapture all those visas, hopefully, that has not been used and they put it back in the basket, there's a big chance they can bring it to almost current for India. And if it is a waiting time of 1 year to 6 months, then everybody's problem is solved because then the job is there, you can file your adjustment of status, etc. Now the H4, the I-140 EAD, I have not really fought for it because I didn't see really a basis to be able to convince them. But I know a lot of people have come up with very good ideas. But unfortunately, I think the approach is wrong. The approach has been with Congress, but at this point in time, with the elections coming, everything, I doubt Congress will be able to pass anything because there's too much problem going on with immigration out there. There's so much, there's a big tug of war. But I think the solution will be to reduce the time on the EB2, and this is something I started fighting for now. If you look on my blog, Immigration Legal Blog, on the right, there is a petition. You can click on that picture, sign that petition, and hopefully we can do the same. And I saw some newspapers started publishing this this article on reducing the EB2, and hopefully if we get good massive support, we will be able to change it and bring it back to something which is more fair. But until then, on the I-140 side, let us see if some people are able to convince Congress or even the Obama administration to give an EAD. I'll be more than glad it happens, okay? But right now I have not really kind of looked into it because I don't see really a good basis to claim it. H4 we were able to claim on showing people, were, especially women, were suffering while others were getting it. But on the I-140 logo say, well, just too bad, we don't have a date. But if they reduce the time on the date, then they don't have any excuse. So at this point,
so
my solution is to go straight.
By this year end, do you predict anything? Before
I think by the... Yeah, if we are able to push it before the election, that's the best. Because if the government changes, I doubt anything. Maybe if we don't know how it is going to what is going to happen if the Republicans or Democrats will get power. Unfortunately, it seems like there is a disconnect. One side they are equating every immigration to illegal immigration. And we know it's not true. Look at you probably suffering. You're not illegal. You're not undocumented. But they are confusing the whole issue. And until someone goes to them, tell them, no, these are different kind of people. This is what we are talking about here, and this is what we're talking about there. Nothing is going to happen because right now when you tell immigration, everybody's saying, oh, you're crossing the border. But people don't, not everybody crosses the border. Most people I know come genuinely on H-1B or on a green card. But until people go and explain that to the government like we did on the H-4, nothing is going to happen. Nobody is really willing to explain because most people don't understand the concepts. And even me, when I try to explain, it's so confusing that I can confuse more people. So we are in a catch-22 situation. We just hope that we can continue the fight. And my goal now is to reduce the time. If we can reduce the time on EB2 to stick to 1 year like it should be, or maybe 1.5 year max, people will not have this issue of I-140. And even the H-4 will not even be necessary at this point. Okay?
Okay. Thank you.
Okay. Good luck to you. Help us out. Get people to sign the petition. It's on my blog, Immigration Legal Blog. On the right side, a blue picture. Just click on it and sign that for me, please. Okay? And you can sign with Facebook or with your email. Let me take another call. I think we're almost done with the show. This is Shah Peerally. You're live on air.
Hi, Mr. Shah Peerally. This is Harinder calling from Tracy. I have a question about the H4 EAD. So, the thing is that me and my wife, we both have approved I-140s, but my wife's priority date is about 1 year before me. So the thing is, if she comes on H4 and gets her EAD, Then in the course of time, when the dates are current, does she have to come back on H4 to have her green card thing, or does she
No,
have
she
to come
just
back on H1 to have her green card approved, or does she can she continue on the H4 EAD and at the same time she can apply for 485?
No, she doesn't have to go on H1 because the H4 is the same as the H1 when it comes to the dual intent. No, she doesn't have to. She just go ahead and enjoy. Just like someone who's an H1, their spouse is an H4, when they're filing adjustment of status, they don't have to shift to any kind of other visa. No,
Okay.
she will be able to just go ahead and enjoy
But the thing is that the I-140 would be her I-140 dates are 1 year ahead of mine. So if she is on H4 at that time and her dates become current, can she apply for the 485?
Yes.
Being on H4?
Yes. Oh. Category yes, because the H4 is still the status and it's a dual intent status, so you're fine. Okay, you don't have to worry on that part. Okay, that's very categoric. Okay, so ladies and gentlemen, we're almost done with the show. We have 2-3 minutes to go, so I wanted to say thank you. We had a lot of callers today, and for those who I'm not able to take their call, I apologize. And I wanted to say thank you to German. And anything I told you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And before I finish, I'm going to talk quickly about debt settlement. This is another area of law that we handle. And this is where people who have problems with their credit cards, sometimes student loans, second mortgage on their house, and you name it, anything that you owe and you cannot pay and you're facing hardship, we can negotiate those loans for you. The way it works is, for example, you owe $10,000 on a credit card. We can negotiate it and bring it to a lower value, maybe $2,000, $3,000, depending on the case, and then they forgive you for the other money that is left. And to do that, we need to negotiate it. And what we do, we work on the case. If we get an approval for you, a deal, then we will charge you. We don't charge you in advance when it comes to debt settlement. We can do the same for people who have judgment against you. For example, someone fighting you, they file a lawsuit, they win the lawsuit, and now you don't have money to pay them. The problem, if you don't pay them and you have assets, for example, a bank account, they can put a levy that bank account. If you're working, they can garnish your paycheck. And if you have a property and have equity in it, or even a car or anything that are asset, they can pretty much kind of put a lien on those properties. So you don't want all this to happen. Let us negotiate those loans for you. We have done thousands of those cases, hundreds of them, not thousands, but hundreds of them, and we have been very successful. Doesn't mean we're going to be successful in your case, but so far we have done pretty good. And the good thing is that we don't charge it until we get something good for you. So give us a call at the office, 510-742-5887. Same number, 510-742-5887. And for the debt settlement, the website is yourdebtsettlementattorney.com. yourdebtsettlementattorney.com. For information, the website is splgpc.com. And also, I publish a regular update on my blog, immigrationlegalblog.com, and we also have started a blog specifically for H4 EAD because it's a big thing. It's called H4TO EAD, H42 EAD, not number 2 but TO, H42EAD.com. Check it out, and it seems like it's gathering a lot of momentum because I update it. One of the things I was talking about earlier at the beginning is a S765 form that we need to use to get the case done has not been issued yet. It has not been revised for us to file it. So we hope within the next week we should get it. And for those who want to apply, need help, feel free to call our office. We're not charging much for those, but we will help you. 510-742-5887. I thank you all, ladies and gentlemen, for listening. Next Monday, you might be listening for a recorded show. It all depends. I have a case in immigration, and I might be late. And also Thursday, I have another one. So you might be listening to 2 shows which are recorded, but that doesn't mean you'll still get good information. You can still call us at the office, 510-742-5887. Thank you, German. Thank you very much, ladies and gentlemen. Anything I told you today is educational in nature. You should not act or refrain to act only on the information provided. You should contact an attorney if you have any questions. Again, the number 510-742-5887. Thank you very much, ladies and gentlemen. Goodbye. You'll hear me soon and next week. Bye-bye.
Visit desi1170am.com and stay connected to your favorite hosts. Watch